The courtroom returned to session with a technical and highly forensic focus. As expert testimony resumed in the matter of people of the state of Michigan, Ves. Julian Carey, the physical environment remained consistent with previous hearings. A formal courtroom where the atmosphere, while calm, carried a concentrated seriousness due to the complex nature of the digital evidence being reviewed. The emotional tone remained measured, but the intensity grew as both sides moved deeper into the forensic mechanics of email activity and computer. Usage judge name not specified maintained her steady and composed demeanor throughout the hearing. Her rulings, particularly around evidentiary objections to expert reports, were thoughtful and grounded in procedural fairness. She listened intently as attorneys debated the admissibility of detailed forensic documentation, overruling objections. While consistently explaining the rationale behind her decisions, her tone was respectful but firm. Her patience allowed the expert to guide the court through intricate technical explanations. The defendant, Julian Carey, remained a peripheral presence during this stage, with no direct interaction noted. In the testimony, her continued silence did not diminish her relevance, however. As much of the session revolved around a shared laptop associated with her alleged activity, the defendant's presence was described earlier as cooperative, and there was no indication of disruption or disengagement in this portion of the hearing. The central figure in this session was once again Detective Kevin Parvis, also referred to as Detective Harrison, experienced digital forensic analyst. He resumed the stand to provide further expert insight into the shared laptop's forensic image, particularly focusing on artifacts related to a disputed email. His testimony was detailed and analytical, including descriptions of specialized software like FTK Imager and data carving tools used to retrieve deleted artifacts. He explained the forensic imaging process, challenges encountered with software versions, and how he ultimately upgraded tools to successfully extract data. Parvis described discovering that the laptop's native Apple email application had been deleted significantly within moments of the disputed email's transmission. He then explained how he used low-level forensic tools to locate residual data in the Windows Search database, ultimately recovering metadata artifacts showing that the email was manually accessed at 6 hours, 8 minutes, and 0 seconds p.m. The transmission logged 1 second later. According to his testimony, this sequence of events strongly suggested user-initiated interaction rather than an automated or scheduled message. Legal counsel on both sides remained actively engaged. The prosecuting attorney structured the direct examination clearly, allowing Parvis the time and space to explain highly technical concepts for the record. The defense, led by attorney Michael Balagna, maintained a skeptical posture, continuing to raise appropriate objections, particularly around the admissibility of reports. Although these objections were overruled, they reflected ongoing vigilance regarding evidentiary integrity. The session flow was smooth, although the high level of technical detail occasionally required pauses for clarification or document reference. Despite the complexity of the material, the courtroom remained respectful and attentive, with a shared understanding that the digital trail being discussed could significantly shape the trajectory of the case. This segment deepened the evidentiary record with advanced forensic interpretation, underscoring how expert analysis of subtle computer behaviors can become central in evaluating events and actions. As the hearing progressed, it became increasingly clear that precision and timing were the linchpins of the narrative under legal review. Welcome to our channel, where we present educational excerpts from publicly available courtroom live streams. Each video is carefully edited to highlight key moments that illustrate the workings of the judicial process, offering viewers a respectful and informative look into real-life hearings. Our mission is to promote public understanding of legal procedures by focusing on the conduct, dialogue, and decisions that shape a hearing. These segments may include judges, attorneys, witnesses, and other participants, all referred to respectfully as subjects under review or parties in the hearing, with added commentary and context. We aim to provide legal insight while preserving the integrity of the proceedings. We avoid speculation or sensationalism and instead emphasize transparency, clarity, and respectful observation. Thank you for joining us in this space where real cases meet educational purpose. We invite you to watch, reflect, and engage thoughtfully.
You said. Okay. No, I got it. We need to see your list because I didn't address.
This one was withdrawn. H was withdrawn. And B was not admitted.
Got it. But then,
And then I have C through F.
okay. Right. And those are the ones I'm more worried about because on the people's side, you only have one.
Just A, just one. Yeah.
Okay. And I just want to make sure we get it clear on the record about that. Court calls case, People State of Michigan versus Julian and Carey.
Ashley Lundy for the people.
Good evening, Your Honor. Michael Balagna on behalf of Julian and Carey, who's present in court.
All right. Your name, ma'am?
Julian.
All right. Thank you. All right. Just some housekeeping things here, counsel. I have a note that at the last hearing, you had submitted to the court exhibit C through F. But I don't know that I don't have notes of testimony regarding those. And C through F were not addressed at all.
Yes, Your Honor, that's true. The only exhibits that were admitted, we just confirmed with Ann, are defense exhibits A and G.
Yes.
Those can be returned. I'm not going to be going.
You will not be
I
using.
don't think I'm.
Okay. All right. That's fine. I just wanted to make sure.
As well as People's One. Those are the exhibits that have been admitted at this.
Correct. I didn't have a problem with any of people's exhibits, so we can hand those back. I didn't have a problem because I only had one. I had a note that was admitted. I had the admitted, no, those go to defense. And I had defense exhibit A was admitted, B was not, G was admitted, and I think H was withdrawn. I just did not have anything regarding those exhibits, and I just wanted to make sure the record's clear.
B wasn't.
Pardon?
No, B was not
Not
admitted.
admitted. No.
B was not.
But not. That's what I thought.
Okay. All right. I think that's what I said. So I think we have it. All right. We ready to continue,
The
folks?
people are ready.
All right. May I call your next witness?
Alex Phillips, Your Honor.
All right. Sir, please come forward and be sworn.
Before you take a seat, raise your right hand. Do you solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State spell your first and last name for the record.
Alex, Alex, Phillips, PHILLIPS.
You may.
Thank you, Your Honor. Sir, how are you employed? In what capacity? How long have you been in that position?
Approximately 5 years.
Were you so employed on or about November the 20th of 2023?
Yes.
Did you go to the Scioto Township office on that date?
I did.
For what purpose? And when you went to Scioto Township on the 20th, what were you going there to do on that date?
On the 20th, I believe, was to retrieve the laptop, reference the initial complaint.
Did you retrieve it?
I did.
Where did you take it?
Back to Station 7
For what purpose?
for safekeeping until detective forensic. Will you check it?
Not your department, correct? Okay. May I have one moment, Your Honor?
Yes.
You log in into a secure location at Station 7 when you kick it in?
I do not recall.
Okay, thank you. I'll pass the witness.
All right. Cross-examination.
Thank you, Your Honor. Just briefly. Good evening, Deputy Phillips. Now, are you the officer in charge in this matter?
Yes.
And on November the 16th, were you working on duty that day? And before I question any further, Your Honor, I'm going to go beyond the scope of that.
I'll let you go.
But I'm going to be brief, but I know that I'm going to
As long
ask
as
questions
it's-
that are not.
As long as it's relevant.
Okay, thank you.
Go
Thank
ahead.
you. I just wanted to let you know that. Thank you. And so you took the initial report that evening from Mr. Will Hathaway, is that correct?
Yes.
And he told you that, I mean, the complaint was just generally that his email had been breached. I think you said in your report. Is that right?
Your Honor, I do think that is hearsay. I object.
I'm just establishing.
Regarding Hathaway's statement,
Yes.
I'm going to sustain that.
All right. Well, I'll move past that then, Judge, and I'll go
Well,
to.
hang on a second. Restate your question again.
I was asking him what was the general allegations, the nature of the complaint.
No, I'm going to change my mind on that. I'm going to let that be answered as long as and we'll only be taking the responses to go to this officer's state of mind and what he may have done.
Thank you, Your Honor.
All right.
Yeah,
Go
thank
ahead.
you, Your Honor. And so the general allegation wasn't it that and I think Mr. Hathaway let you know that his email had been breached. In other words, somebody accessed his email and sent an email to another official at Scioto Township. Is that right? Okay. And then on November 18th, according to your report, you spoke with Detective Parvis. Is that correct?
Yes.
And you gave him a short summary of the allegations. Is that right?
Yes.
And based on this short summary that you gave, Detective Parvis told you that criminal actions had been taken. That's according to your report. Is that right?
Your Honor, objection, hearsay.
Oh, I'll overrule it.
Thank you, Your Honor.
And when he made that statement to you, you put that in your report, correct?
Yes, sir.
But that was on November the 18th, correct?
I believe so.
And that was 2 days before you just testified that you went and retrieved the laptop that's at issue in this case. Is that right?
Yes, sir, that sounds right.
Okay. So did you think his declaration? Well, I'll withdraw that question. The warrant was issued for my client on June the 13th of 2024. Is that right?
I believe so.
But without tying you to a particular date, was it around June of last year that the warrant issued?
That sounds right.
Okay. But you didn't swear to it. Is that right? And Officer Howard Schaefer did. Is that true?
Yes, sir.
Did you provide all of the relevant evidence and information to Deputy Schaefer prior to his swearing to this?
I'm not entirely sure how he reviews the reports, but he reads the report that's submitted and swears to it, is my understanding.
Okay. And before you sought the warrant, did you do any investigation yourself?
I interviewed people.
Did you interview Ian Hubert?
I did.
Did you write a report on that? Or did you like a separate report for Ian Hubert's interview?
It was in one of the supplemental reports, yes.
All right. So it would be like a paragraph or two in the report, but not a separate report. Is that right? Do you know when you interviewed him? If it isn't in the report?
I believe it was in the report, but off the top of my head, I don't know the exact date.
Would it refresh your memory to look at your report?
It was.
Yeah, approach.
You may.
I'm just showing. Look at that and let me know if that refreshes your memory, please. And if that's not the right report, please let me know that too. Did that refresh your memory?
Yes.
And do you recall now when you interviewed Mr. Hubert?
I believe it was the next day.
When you say the next day, would that be the November the 17th?
Yes, sir, I believe so.
Okay, so when you say the next day, so the next day, the day following the day that he came in and made the complaint, correct? And did you also interview Mr. Will Hathaway?
Yes, sir, I did.
And did you also interview Julian Carey?
Yes, sir.
Did you interview Jessica Flintoff, the individual who is alleged to have received the forwarded email in question? If you didn't interview, what's the reason why you didn't? Were you actually in charge of the investigation, or at some point did you turn it over to Detective Parvis? Okay, just because I don't understand it, would you consider Detective Parvis then the investigator in charge of the case, or are you both investigators in charge, or is there no designation? I don't know.
Listed as the officer in charge, but I think Detective Parvis and.
All right, just so that I don't waste the court's time, especially at this late hour, I'm not going to ask you any questions. Then, if you don't know, you don't know anything about Microsoft Purview audit logs or anything like that go to the heart of the issue in this case on the computer side of it. You don't know about that stuff, correct?
Correct.
All right. Did you interview Francis Zuma, the recipient of the calendar invitation in this case? And again, is there a reason that you didn't, or was the duty at some point to interview witnesses, was it turned over to Detective Parvis?
Joint venture.
Okay. But do you know why she wasn't interviewed, if she wasn't?
I don't know.
And if I could approach Your Honor with Exhibit G admitted, can I approach Your Honor?
Yes.
Do you recognize Defense Exhibit G? Have you ever seen that document?
I don't believe so.
Okay. Did you, during the course of the investigation, did you speak with one of Ms. Carey's attorneys named Mark Chutko?
I believe I spoke to an attorney, I'm not sure though.
Okay. Did Mr. Chutko provide you a copy of Exhibit G, if you recall?
I don't know.
You don't recall? Okay. And do you see what's highlighted on that page? Could you just read that?
Objection, Your Honor, this exhibit speaks for itself.
I want to ask him about it. What
Well,
it
you
says.
see the highlighted, the part that starts with sorry?
Well, he said
Yeah, I just
he
wanted
did as
him to
well.
read it so I can ask a question about it.
Well, read it, not out loud, just.
All right, read it to yourself if you
Go
will.
ahead, and then you can ask questions.
Okay. Okay, so it's an email. You see there's an email to someone named Kim Moore, amongst other people, by looks like Mr. Will Hathaway. Do you see that?
Yes.
And do you see that the email says, sorry, this email seems to have sent itself again when I logged in just now? Do you see that?
Yes.
Okay, would that have been an important piece of evidence for your investigation if you're trying to find out whether or not the email in question was sent by Mr. Hathaway or whether it was sent by Ms. Carey? Would that have been an important piece of evidence, do you think?
Your Honor, I'm sorry.
Well, I'll rephrase the question. It was a poor
Thank
question.
you. That was.
Yeah, I'm sorry. If you had seen this as you read it, as you heard me read it now, and you read it to yourself, would that have been something that you would have put aside or said that this is important to the case?
Yes.
And do you recall doing that? So then do you think you didn't receive this or do you not recall?
I don't believe I received it.
Okay. All right, thank you. I'll grab that back. And you didn't interview Kim Moore, the woman on this email, did you?
No.
Did you investigate the relationship between Julian Carey and Mr. Hathaway to see if there's any acrimony between the two of them or any motive by either one of them to either send an email or say that someone sent an email? Did you look into the relationship, I guess, in your investigation?
I was informed of some tension.
Okay, but did you interview anyone based on what you were informed or no?
I don't believe I interviewed anyone specifically about issues they had. I believe it was brought up during the course of speaking to people.
Okay, and then on November 19th, the day before you went and you got the computer, did you interview Julian Carey at her home? And did you give her any notice that you were going to come out and interview her?
I don't believe so.
Okay, and you did that at night, right? Is that right?
Yes, sir. Afternoon.
Okay, and did you go by yourself?
I believe so.
Was there a reason that you went at nighttime without giving her any notification? Did you consider maybe calling her and letting her know you were coming?
I generally just go knock on people's doors first if I can, and I work at the time I worked 4 to midnight, roughly.
So it was really based on your shift is why you went later in the day, as opposed to some trying to gain some kind of tactical advantage. Is that right? And she agreed to speak with you, did she not? And she invited you into her home? Was she cooperative? And did she agree to answer questions about what happened? She did. And did she, and isn't it true that she didn't admit to doing anything illegal? Is that correct?
This time is the hearsay.
Sustained.
All right. In your report, I noticed that you updated your report on occasion. Is that fair to say?
Yes, sir.
And one of the updates in your report, you write, William requested to have Detective Parvis look through the computer. And I can show you a report again if you don't recall that. It's on page 5 of your report. Would you like to see that again?
No, I remember.
All right. So was it the fact that William Hathaway requested that Detective Parvis look at the computer? Is that what caused you to go get the computer?
I believe I was coordinating with that Detective Parvis, trying to examine the computer to see if that would be beneficial for evidence.
Okay. But you weren't doing it just because William Hathaway asked for it. That was Detective Parvis who said you need to get the computer. Is that right? Now, I understand that you took the what we call the shared laptop. We're going to call it the shared laptop, this shared SIO laptop. You took that to get to Detective Parvis to examine forensically, correct?
Yes.
And did you ever take William Hathaway's cell phone? It was never imaged as far as you know, correct? It was never extracted, I guess is the right word.
As far as I know.
Okay. And did you try to determine what other devices that Mr. Hathaway was using at the time this email incident occurred?
I don't know.
So you don't know if he was using an Apple computer, for instance, an Apple laptop? You don't know? And Detective Parvis never had you go get any other devices besides the shared laptop, correct?
Correct.
Is there any reason why you didn't image the other devices if the issue had to do with who sent the email?
Any reason he didn't what?
Any reason that he didn't get any other devices to see what the activity was on Mr. Hathaway's devices?
After speaking to Detective Parvis, he recommended the laptop. A little bit out of my wheelhouse.
You were kind of letting Detective Parvis make the calls on what he needed forensically, correct?
Yes, sir.
And do you remember on February 9th of 2024, Mr. Chetko providing you a copy of Exhibit G? I was just wondering if the date would help you. Do you remember getting something from Mr. Chetko in February of 2024?
I do not.
Okay. And are you aware of Mr. Chetko sending you a copy of a report done by a company called N1 Discovery?
Not that I recall.
And my last couple questions have to do with this. You were aware at the time that you were investigating this initially, and I'm talking about in November of 2023. You were aware at that time that William Hathaway was the supervisor of Scioto Township, is that right?
Yes.
And the fact that he was the supervisor of Scioto Township, did that have any effect, either positive or negative, on the way you handled your investigation?
Yes, I would assume.
Okay, can you explain that?
Given that it's a high profile nature, generally it's better to inform people above supervisors and so forth.
So as far as notifications, you were more careful with that because of the complainant's position?
Yes.
Anything else that you did differently? So there was no special treatment given to Mr. Hathaway, certainly, was there?
I don't believe so. No.
Thank you. I have no further questions.
Any redirect?
Yes, Your Honor. Deputy, do you still have a defendant's exhibit G with you?
Sorry.
Okay, great. I'm just, actually, if I can use the system, I may prefer that. May I, Your Honor?
Yes.
Thank you. Deputy, you testified earlier that the date that you initially went to this call and sort of worked on this was in what month of what year?
2023.
And this should be live now. This is defendant's exhibit G that's previously been admitted into evidence. You were asked questions about a few moments ago. Do you recognize this?
Yes.
What's the date on this email?
1/31/2024.
So when your investigation was happening initially in fall of 2023, that email hadn't even been sent yet? Thank you.
Oh, thank you. You may step down. Thank you, sir.
Is this the excuse, Your Honor?
No objection.
All right, this witness is excused. Thank you, sir.
Thank you, Your Honor.
May call your next witness.
Kevin Parvis.
Sir, please come forward to be sworn.
This session further cemented the significance of digital forensics as a foundational component in the case of people of the state of Michigan, Julian Carey. Presiding over the proceedings, judge name not specified remained composed and judicious throughout. Her oversight during objections to the admissibility of expert reports was thoughtful and deliberate. She patiently considered arguments on both sides before ultimately ruling in favor of admitting the reports as the experts. Professional conclusions. The judge demonstrated not only control over the legal procedure, but also an openness to understanding the technical language that often accompanies digital evidence. Julian Carey, defendant, maintained a consistent presence marked by composure. In silence, she was not directly engaged during this portion of the hearing. But her earlier cooperation with law enforcement, paired with the centrality of the shared laptop attributed to her workplace, kept her at the heart of the evidentiary discussion. The lack of emotional reaction or interruption suggested a participant who was prepared to let the facts be handled through legal channels. At the core of the session was Detective Kevin Parvis, whose role as a digital forensic expert was critical. Parvis, also identified on record as Detective Harris, presented a high-level overview of his third forensic analysis report and walked the court through some of the most technically complex aspects of the case. He explained how he conducted a full forensic image of the shared township-issued laptop using FTK, imager software not available to the general public and specifically licensed for professional use. When initial versions failed, Parvis upgraded his tools to ensure accurate data acquisition. His adaptability and commitment to precision were evident. Parvis's findings carried weight. He discovered that the desktop Apple email application had been deleted at approximately 6:24 p.m. shortly after an email at the center of the hearing was sent. Using low-level data recovery and search databases embedded in the Windows 10 system, he identified artifacts of the email in question. According to his testimony, the email was accessed at 6 hours, 8 minutes, and 0 seconds p.m. And a corresponding server log confirmed the email was sent at 6 hours, 8 minutes, and 38 seconds. These near-simultaneous timestamps indicated, in his expert opinion, that a human being had opened the email immediately before it was transmitted, a sequence not consistent with automated or scheduled messages. He further clarified that scheduled emails would not create such access artifacts. The prosecuting attorney structured this direct examination well, ensuring that each element of Parvis's forensic process was clearly presented and tied directly to the evidence. The prosecution allowed ample room for the expert to elaborate without overwhelming the record. Balancing precision with clarity, defense counsel, including Michael Balagna, remained firm in their stance. Balagna's repeated objections particularly, on the basis of hearsay and the admissibility of written reports, were consistent with his role as a guardian of procedural fairness. Though the objections were overruled, they served to remind the court of the importance of distinguishing between oral testimony and written analysis, especially in cases where conclusions are drawn from technical sources. The courtroom tone was again serious, respectful, and detail-driven. With all parties locked into a narrow focus on forensic methodology, there was little room for theatrics-only facts, interpretation, and rebuttal. It was a hearing that valued expertise over emotion, structure over spectacle. From this session, viewers can take away an appreciation for the role technology plays in modern hearings and how data, even after deletion, leaves behind a story. Judge name not specified guided the court with fairness. Julian Carey remained reserved and present. Detective Kevin Parvis brought a credible, detailed, and thoughtful contribution, and both legal teams maintained diligence in their pursuit of clarity. If you found this hearing insightful, consider subscribing, turning on notifications, and leaving your thoughts below. Your engagement supports thoughtful conversation around real-world legal processes and public transparency.